In this podcast, we talk about different forms of acceptance. As we've already mentioned, to accept an offer, the acceptance has to be communicated from the offeree to the offeror. And this goes back to the principle that the minds of the parties must meet. The offeror, as the master of the offer, is entitled to stipulate the form of acceptance. So the offeror can say that she needs acceptance by writing or at a particular time or in a particular location. So for example, if I say that acceptance must be made verbally to me, well, the contract may not be formed if you write a letter to me accepting my offer and sending it to my house. Now, why do I say may? Legal theorists have said that while strict conformity is usually required, there may be an exception. If an offeror is not prejudiced by the non-compliance with the specific mode of acceptance and had no special reason for demanding it, then the offeree could communicate acceptance by another route, no less advantageous to the offeror. Note, it is doubtful if the offer says that it must be accepted at a corporation's New York office and the offeree sends an acceptance letter to its Tokyo office. So a corporation would have good reason for requiring communications to be addressed to particular places, and a reasonable offeree can be held to know that. Sometimes the offeror does not insist on any particular form, and in that case, the offeree is free to accept in any reasonable form. Different forms of acceptance are written or spoken word. Now, these are the most commonly used forms of acceptance. But there are other forms which have left us with some difficulty. There's silence and there's performance. Bilateral contracts and unilateral contracts differ in how acceptance is carried out. In an offer for a bilateral contract, that is generally accepted through a promise, whereas an offer for a unilateral contract is accepted through performance. Recall Carlyle and the Carbolic Smoke Ball. The directed use of the product was how acceptance would be done. In Williams and Carwardine, providing information about the murderer was acceptance. Courts like to presume a bilateral contract because it protects parties' reasonable reliance. There can sometimes be unfair results with unilateral contracts. In a unilateral contract, an offeror can revoke the offer up until the last minute before the completion of performance. Why is that? The reason is because until performance, the promisor, the person making the promise, is not bound. This will be a problem if the promisee has already spent time and money preparing to perform, but hasn't yet performed or completed performance. Then the offeror withdraws the offer before performance has started or been completed. So for example, in Carlyle and the Carbolic Smoke Ball, assume Ms. Carlyle bought the smoke ball and used it for 3/4 of the stipulated time. And before she went any further, the company revoked its offer for the reward. Well, that's a unilateral contract. And even though Ms. Carlyle has already spent the money for the smoke ball and the time using it for the prescribed periods, it doesn't matter because the contract has not been accepted. That leads to unfairness. It's unjust. If a party has reasonably relied on a promise and has acted accordingly, but hasn't yet finished performing, it is unfair for that promise to be revoked. That party has spent time and money preparing and partly performing, and the party may have also given up other opportunities in order to perform this contract. This is the problem with unilateral contracts, hence courts presuming bilateral contracts. The Dawson and helicopter exploration case is a good example. In this case, the plaintiff, Dawson, was a prospector with information regarding a prospective mineral claim in northern BC. Dawson disclosed that information to the defendant, Helicopter Exploration Company, and the defendant expressed an interest in the property and offered an arrangement with the plaintiff under which the plaintiff would accompany the defendant to the area, guide them to the properties in question, in return for a 10% interest in whatever claims the defendant could stake in the area. The defendant also stated that the proposal would depend on the ability to arrange for a helicopter. On April 12th, the plaintiff agreed to the terms set out by the defendant and was prepared to travel to the site at a time suggested by the defendant. On June 7th, The defendant told the plaintiff Dawson that he had consulted someone else who told him it was almost impossible to operate in the area. The defendant told the plaintiff that the effort made to get up there wouldn't be worth it, so the plaintiff should make other arrangements if he still wanted to go. The plaintiff didn't reply to this correspondence, and what happened is that the defendant subsequently explored the area and staked and exploited the claims for himself. So what we know is that the defendant either lied to the plaintiff or overcame the unexpected difficulties he had told the plaintiff about. The position of the parties was that the plaintiff discovered the defendant's activities and sued for breach of contract. The plaintiff argued that the contract still existed and the defendant breached it by exploitation. The defendant argued that the offered agreement was unilateral and could only be accepted upon the plaintiff's accompaniment on the trip to the area in question. No such trip has occurred, so the offer had never been accepted. The issue here is, when will an offer be classified as pertaining to a unilateral contract? And the court said there is a presumption that an offer pertains to a bilateral contract, not a unilateral one. The reasons were such that, first, the offer for a unilateral contract is revocable any time prior to full acceptance. This means that the offeror's position is protected, but there is no protection for the offeree because the offer can be revoked at any time before the offeree fully accepts. The problem here is that the offeree may have already partially performed, and under the orthodox rules, there is nothing to prevent the offeror from withdrawing its offer at any time before full acceptance. Second, a bilateral contract equally protects both the offeror and the offeree. Since the contract is made immediately upon the exchange of promises, neither party can unilaterally withdraw from the agreement. Third, the presumption of the bilateral contract is said to generally accord with the expectations of the parties. The interpretation for a bilateral contract, in order that the transaction shall have such business efficacy as both parties much have intended that in all events that it should have. Quote, so both parties are protected by having made mutual promises. On the facts here, the presumption applied, and the defendant's offer was for a bilateral contract. The plaintiff had accepted the offer. Even though the plaintiff did not expressly say words to that effect, the situation was, quote, instinct with obligation. And what that means is good faith with the contractual obligation. So while acceptance must be clear, it does not necessarily have to be express. Acceptance may be gleaned from the totality of the circumstances. What are the promises here? If we're going to find a bilateral contract, both parties must have promised something. Well, the plaintiff effectively promised to try to guide the defendant to the claim, and the defendant promised to pay 10% interest in any claims that were found. In other words, the defendant's offer of a bilateral contract were subject to a condition subsequent. It would be required to make reasonable efforts to locate a pilot. It would pay the plaintiff a non-assessable 10% interest if the claim was successfully exploited. The plaintiff accepted the offer of bilateral contract through the promise to perform, which was guide the defendant to the area of claim, and the defendant breached the contract by refusing to transport the plaintiff to the area. Another area that is problematic is when there is acceptance by silence, or purported acceptance by silence. Recall the general rule. The offeree must communicate acceptance to the offeror or someone authorized to accept acceptance, such as an agent. Which follows, silence alone cannot constitute acceptance. Why is that? Well, with silence, there is no manifestation of a willingness to enter into the contract on the terms offered by the offeror. That is, there is no way to assess on a reasonable person basis whether there was consensus between the parties. Take us to Feldhaus and Bindley. Here the plaintiff uncle initially believed he had bought a horse from the nephew for £30. The nephew believed the price was 30 guineas. The plaintiff offered to split the difference and buy the horse for £30 and 15 shillings. And the plaintiff stated, quote, if I hear no more, I will consider the horse mine. The nephew did not respond to the plaintiff's letter. The nephew nevertheless believed that he had sold the horse to the plaintiff. The nephew held the auction, but told the defendant auctioneer not to sell the horse. The defendant forgot the instructions and sold the horse to a third party for £33. The defendant auctioneer wrote to the plaintiff explaining the mistaken sale of the horse, and the nephew wrote to the plaintiff saying the horse had been sold. Quote, "The horse I sold you is sold," which indicates, of course, that the nephew believed the earlier contract had been formed. The plaintiff brought an action against the defendant auctioneer for conversion of the horse, and the defendant insists that he had a valid contract. The plaintiff sued the defendant in the tort of conversion, which is the wrongful possession and disposition of another's property as if it was his own. The jury held for the plaintiff and awarded £33 and 15 shillings. The issue here was silence alone serve as acceptance of the offer, and the ratio is no, not alone. The defendant is not liable in conversion because the horse did not belong to the plaintiff. No contract was formed between the plaintiff and the nephew through silence. The letter sent by the nephew, quote, "The horse I sold you is sold," could either have constituted acceptance of the uncle's letter or as a memorandum of the completed bargain, which would be a letter confirming the agreement had taken place. And the court found for the first choice, that the contract was formed later, but not at the time the horse was sold by the auctioneer. And the policy rationale here is that acceptance is determined on a reasonable person test. It is irrelevant that the parties believed the contract existed before the auction. It is desirable that acceptance requires outward manifestation. We'll talk about this case right after we talk about St. John's Tugboat, which is the next case. In St. John's Tugboat, the defendant operated an oil refinery in the harbor at St. John, and the oil tankers needed tugboats to guide them into the harbor. The defendant did not have a sufficient supply of tugboats to meet the need for tankers, so they rented tugboats from the plaintiff for this purpose. The parties previously had entered into a series of contracts for the hire of tugboats, and those contracts had expired. The plaintiff wrote to the defendant stating that no tugboats would be available in the coming months unless it was arranged between them, and the defendant replied insisting upon special rates, and the plaintiff offered particular tugboats at specified rates. The defendant orally agreed to hire one tugboat for 1 month, and that contract was twice extended. The contract expired, but the defendant continued to use the services of the plaintiff's tugboats. The defendant paid for some time, but then refused payment and argued that there was no contract because there had been no express acceptance. And the issue was, did the defendant's conduct constituting continuing acceptance of the offers for the tugboat service, or, in other words, can silent acquiescence be construed as acceptance? The ratio is silence will not constitute acceptance. Liabilities are not to be forced upon people behind their backs. Silence, however, may also constitute acquiescence. If a person is silent and thereby acquiesces to a benefit being done for him, and takes the benefit of it once it's done, he has implied his promise to pay for it. And again, we apply the objective test, whether the conduct, unaccompanied by verbal or written undertakings, can constitute acceptance of an offer so as to bind the acceptor to the fulfillment of the contract. Now, if you apply this to the facts, the standby services continue to be rendered for the benefit of the respondent, so it was not unreasonable to draw the conclusion that the conduct of the respondent said he was accepting the continued special services. Let's talk about why silence can't constitute acceptance. In Feldhaus and Bindley, the court said, quote, "The uncle had no right to impose upon the nephew a sale of his horse unless he chose to comply with the conditions of writing to repudiate the offer. Here the offeree is forced to take positive steps to prevent the formation of a contract. This principle is enunciated in legislation which protects consumers in each province." But, while that principle makes sense, the issue is the fact scenario in Feldhaus and Bindley different than this? We accept that goods should not be foisted by one party on another. But in this case, there are two parties who had already been involved in a voluntary negotiation. Silence as acceptance did not constitute as unreasonable in the situation. The nephew believed that his silence resulted in the formation of a contract. The American Restatement of Contracts suggests that silence should be able to constitute acceptance in a case where the offeror has given the offeree a reason to understand that assent may be manifested by silence or inaction. The Restatement of Law is simply publications from the American Law Institute that provide general statements of law. These are respected secondary legal literature that are often cited by the courts. So, in sum, people are not to have obligations thrust upon them without their consent. In general, people need to indicate consent by a positive action, and silence cannot constitute consent. But that principle is sometimes qualified. In St. John's Tugboat, the existence of some relation between the parties, the known or expected reliance by one party on what the other has done or undertaken to do, may create a situation where there will be a positive obligation to act. And in these situations, silence may expose a party to liability. One must ask in these situations, is what the offeree did, either by doing nothing or by its conduct, reasonably relied on by the offeror as indicating acceptance of the offer?